Good morning to you all. This is Daniel Erasmus speaking to you long distance from the United States of America. I hope to give you some introduction as to the importance of the policies that are being marketed with Hollard as the underwriter and why it is important for taxpayers, particularly running smaller businesses and having exposures to a variety of tax audits that might take place, why it's so important for them to take out this policy, and give you a little bit of background on the question of taxpayers' rights and remedies. The issue was around Section 179. Now, Section 179 is a very problematical section in that it is a section that is oftentimes used by SARS to collect outstanding taxes from third parties. And I'm sure that many practitioners and businesses at some point may be exposed to this fairly draconian power. And what it says, a senior SARS official may, by notice to a person who holds or who owes or will hold or owe any money, including a pension, salary, wage, or remuneration, require the person to pay the money to SARS in satisfaction of the taxpayer's outstanding debt. You might be a creditor of a taxpayer, you simply get this notice. Now, if you are the taxpayer, you generally speaking are completely unaware that this notice has been sent to one of your creditors, and that could possibly also be the bank. Now, what it says here is that unless you, the creditor, are unable to comply with the notice, and it doesn't say on what basis, then SARS may amend that notice. But I'm more interested in section 179.4, where SARS may, on request of a person affected by the notice, amend the notice to extend the period over which that amount must be paid. That, by implication, includes the taxpayer, who I can assure you is usually never notified about this notice being sent out. And you'll see at the top here, it talks about a senior SARS official may, by notice, and that may means it's a discretion. So this 179 notice is not sent out in every given instance when a taxpayer owes money. It is by selection through a particular process by the senior SARS official. That selection process, that word may, is pregnant with meaning, coupled with the fact that SARS should be giving notification to the taxpayer concerned. This never happens. How do you defend your situation? How do you defend such a notification? What steps do you take in order to defend your position? Bearing in mind what SARS would have done is simply nabbed any money that is owing to you in order to satisfy a particular debt. And that is where taxpayers' rights come into play in a very, very practical environment. And what the policy does, it extends the ability for taxpayers to seek the appropriate guidance as well as the appropriate expertise in order to bring the necessary application to stop SARS from doing this, to go to the assistance of the creditor or the bank, as the case may be, in order to assist them in combating the execution of such a notice until such time as the taxpayer has been given an opportunity to be heard. And you might say, why is that necessary? The taxpayer owes the money. Remember, all the taxpayer may have received up to this particular point in time is notice of taxation by way of an amended assessment. SARS has specifically now selected them to implement this draconian measure, whereas there are other measures by which this money can be collected. For instance, by entering into settlement discussions, it might be appropriate for a compromise. It might be that there's an opportunity here to extend the payment or to enter into a payment plan, as opposed to simply going and attaching monies that are due to the taxpayer. And taxpayers' rights include the fact that SARS should use the most appropriate remedy under the circumstances. One size does not fit all. What would be the appropriate remedy here? Is this a taxpayer that has consistently ignored requests from SARS? Well, then you would say 179 would be an appropriate way for SARS to act. But if the taxpayer has never been approached, has never really done anything wrong in the past, why is SARS implementing such a draconian measure without first giving some form of notification to the taxpayer? And so through the policy, we are able to engage experts to tackle SARS on these issues and, if necessary, bring the appropriate application to get to the bottom of why they are doing this and hopefully find a much more palatable way for the taxpayer to meet those obligations in the event that they were implemented correctly by SARS in the first place. That really gives you a feeling of what is capable of being done.